Good afternoon. I want to express my appreciation to Senator Alexander and the Republican Conference for making this hearing possible. As you see, the theme of this hearing is Main Street jobs, protecting Main Street jobs from lawsuit abuse. This seems to be a subject that is not getting much attention in Washington these days, but one that I think has a direct impact on our economy and on our country's future. As we've learned, Dr. Teuscher, one of my constituents from Texas, was going to talk a little bit about what we've done in Texas in terms of medical liability reform and its impact on increasing access to health care. But runaway litigation costs American citizens and businesses that employ those citizens millions of dollars every year. Of course, we all will concede at the front end that it's important to do justice when a wrong is committed. But meritless and nuisance lawsuits have significant costs in terms of the money and the time it takes to spend in litigation. This, of course, in turn drains resources and makes it harder for Americans working to put the economy back on the right track. And as the President talked today about his efforts to help small business, it's important to acknowledge the fact that litigation costs can have a disproportionately high impact on small businesses and their ability to retain and hire new employees. Large corporations usually carry significant insurance and have robust budgets to cover the litigation costs, but smaller businesses may find that one lawsuit can result in legal fees approaching a year's revenue, and that's even if you win the lawsuit in the end. Small entrepreneurs who are netting $100,000 a year after taxes and payroll are prospering and likely creating jobs, but that $100,000 can easily be destroyed by legal fees from even one lawsuit. Too often, for even American Main Street businesses, the costs of being sued, even if the suit lacks merit, can be tantamount to a death sentence for their business. Nevertheless, the leadership of this Congress seems oblivious to these facts and determined to reward political allies and benefactors in the trial bar by passing legislation designed to not decrease, but to rather increase the number of lawsuits in America. We're less than 2 months into a new administration and a new Congress, but already we can see some indications of what is to come. In this Congress, there have already been 3 bills that contain provisions that are intended to increase litigation and create new business for the trial bar. The Lilly Ledbetter Act, which allows lawyers to sue for employment decisions that were made decades ago after witnesses' memories have dimmed or perhaps the witnesses themselves have died, and when it is next to impossible to defend those suits, has virtually made that an open-ended proposition by eliminating essentially the statute of limitations in those kinds of cases. The $700 billion stimulus bill contained a provision that allowed trial lawyers to enter into contingency fee contracts with state attorney generals, outsourcing that work, so to speak, to sue healthcare companies for HIPAA violations, which was previously enforced only by federal regulators. Similarly, the omnibus appropriation bill opened the door for contingency fee lawyers to also do more outsourced work under the Truth in Lending Act. And that's just the beginning. In the coming months, we believe there's going to be yet more bills that will be effectively to the same end. Then there's a so-called bankruptcy cram-down bill, which will increase bankruptcy litigation. There will be efforts to outlaw consumer and employment arbitration, which is, of course, faster and cheaper and more accessible than full-scale litigation, which may be cost prohibitive to many people. And, of course, that kind of arbitration usually is less profitable for the lawyers, but indeed that is the point. How do we cut some of the cost and some of the delay inherent in modern-day litigation, which actually makes justice more accessible rather than less accessible? There will also be efforts to undo the important reforms of the Class Action Fairness Act, reviving the class action strike suit, where trial lawyers may make millions while their clients receive nothing other than coupons as a result of their recovery. Then there will be an attempt to repeal the Supreme Court's long-standing case law on federal preemption. Such a move would allow lawyers to sue in state courts for alleged design and warning defects in products whose designs and warnings were mandated by federal law. The card check legislation will lead to determinations, if it passed, by a federal tribunal rather than at the bargaining table between employer and employee. And the health care reform bill that is central to the President's agenda and certainly to his budget proposal is unlikely to contain certain health care reform that has been proven to reduce costs and improve patient access, medical liability reform. Unfortunately, the health care plan will in the end, I believe, be more likely to increase rather than decrease litigation. The costs of all of this litigation will be significant both from an economic standpoint and in other more general societal costs. Republicans believe that we can and must do better. Runaway litigation has imposed too many costs on Americans for too long, for which American consumers pay, since these are not costs that are absorbed by the business, but eventually, just like taxes, passed down to the consumer. And I think it's fair to say that America cannot sue its way back into prosperity. The Republican Party's first leader, Abraham Lincoln, encouraged his fellow lawyers this way. He said, "Discourage litigation. Persuade your neighbors to compromise wherever you can. As a peacemaker, the lawyer has superior opportunity to be a good man." And these days, I should say, a good woman. Lincoln concluded there will still be business enough. Republicans hold these beliefs close, and when wrongs are committed, of course, compensation should be paid, justice should be done. But the role of the legal system is to do justice efficiently, impartially, and in a manner that preserves the peace of the community and the freedoms of the individual. The legal system should not be a tool to benefit the legal profession at the expense of America's small businesses or our economy in general. I look forward to this afternoon's hearings and the testimony of our distinguished panel of witnesses, and look forward to pursuing, along with my colleagues, a better solution, a legislative agenda of fairness and freedom from wasteful litigation. I'd yield the floor to Senator Alexander for any opening comments he may care to make.
Thank you, Senator Cornyn, Senator Sessions. Thank you to the witnesses who have accepted our invitation to come today. On the American agenda this year are the issues of jobs and health. And the trial lawyer's agenda, it goes directly to the question of whether we'll have more jobs for Americans and whether Americans will have better health care. I want to thank Senator Cornyn, who's a former Supreme Court judge in Texas. Senator Sessions is a former United States attorney in Alabama, for their leadership in this area. And thank Senator Cornyn for chairing the discussion. Senator Cornyn already has mentioned how early in this agenda we see that when it comes to jobs, it seems that the Democratic Congress is more interested in new jobs for trial lawyers than it is jobs for Americans who are not trial lawyers. For example, the stimulus provision, which seemed to stimulate some people to not others, found trial lawyers right at the head of the line. They have new jobs now making arrangements, as the senator pointed out, with state attorneys general. And then right behind it came another jobs for trial lawyers provision. If that's the kind of focus we're going to see, it's going to mean fewer jobs in small businesses as they have to salt away profits in a bad economy to guard against lawsuits which may come. Usually these lawsuits are settled. Sometimes they're not even meritorious, but it adds to the cost of business and it discourages job creation at a time when every American knows we need to create jobs. The one reason I especially appreciate Senator Cornyn having this session is that Republicans and some Democrats, but Republicans strongly believe that any health care reform ought to include medical malpractice reform. In 45 of Tennessee's 95 counties, pregnant mothers have to drive for miles to get prenatal health care or to deliver their babies. In 15 of those counties, pregnant mothers have no access whatsoever to any prenatal care within their counties. The reason is very simple. Doctors are leaving the OBGYN profession in Tennessee and moving away from Tennessee to other states. Whereas in Tennessee at Vanderbilt University, 1 out of 104 medical students graduating chose to be an OBGYN. One of the factors is the high cost of medical malpractice insurance. showing that it makes a difference where you practice. Texas now has a long line of people who want to be in the practice of medicine there. Republicans believe that anyone hurt ought to be compensated, but that excessive punitive damages unfairly limit especially low-income and middle-income Americans' ability to get health care. And in our state, it especially works against pregnant women, people who need prenatal health care and help delivering their babies. So today we want to hear about how the appropriate relationship between lawsuits and jobs can be fashioned so we can be good advocates for that on the Senate floor. I thank Senator Cornyn for his leadership.
Senator Sessions, do you care to make a few remarks?
Briefly, thank you so much. I do believe in the justice system. I think people have a right to seek redress in court, and we should not deny that. But litigation does have cost. We know that litigation often has been a extortion technique where weak or unacceptable cases are filed to extract settlements from companies. We know that with regard to the issue of delivering of babies, Senator Alexander, I understand it's about $1,000 per child as insurance that is carried to pay for that. Some areas it may be more, some areas it may be less, but that just shows the extent of which this cost ripples through the economy. And the same is true with regard to nursing homes. Their insurance costs are extraordinary, and often they and other medical professionals carry out actions that they would not carry out otherwise except for fear of some lawsuit. I would just say that working our way through this in a rational way is what we should do. I believe that's what this panel is about today. President Obama today said that economic recovery depends on the success of small businesses. I heartily agree. And I think if you talk to any small business, the ones I know, they live in dread and in fear of unpredictable lawsuits, and they are also having to pay insurance premiums far above what they feel are necessary, both of which impact their ability to grow and prosper and to hire American people as their employees. So thank you. Look forward to this.
Thank you. Our first witness is Philip Howard, who's long been a champion of common sense legal reform in America. He founded an organization in 2002 known as Common Good, which is known for forging bipartisan coalitions to enact legal reform and combat lawsuit abuse. Over the years, Common Good's advisory board has included Attorney General Eric Holder and former Senators Howard Baker, Bill Bradley, George McGovern, and Alan Simpson. Mr. Howard has authored several books on today's topic, including a bestseller, The Death of Common Sense, which was published in 1995. Even more provocative is his latest book called Life Without Lawyers, Liberating America from Too Much Law, which was released.
Three of us would be disappear, Justice Cornyn, if that were so.
Well, that's why I'm especially looking forward to Mr. Howard's testimony today. Syndicated columnist George Will predicted that Life Without Lawyers will be, quote, 2009's most needed book on public affairs, close quote. When he's not writing books or contributing opinion articles to major national newspapers, Mr. Howard holds down a day job as a partner in the New York office of Covington and Burling. Welcome, Mr. Howard. We'd be glad to hear your opening statement.
Thank you, Senator Cornyn. Thank you, Senator Sessions, Senator Alexander. I'd like to apologize in advance for leaving early. There's a book party for me in New York, and I've got to get back.
I think it's not turned on.
Mr. Howard, I think your the button on your is now on.
You heard it and the public didn't, even better. I will not repeat what I stated in my statement, which includes a number of very specific reforms, including comments on some of the proposals, Senator Cornyn, that you mentioned. When times are hard, the solution, though, is rarely to encourage more litigation. It has the effect of a dog biting its wounds. You want to move forward and try to repair the damage done to an economy, to have positive energy in business, not the negative energy of finger pointing. So in general, if there's a need to look back at what went wrong, I would encourage Congress to look at special administrative proceedings or other fast-track proceedings which don't have either the cost or the adversarial heat associated with the current litigation process in America. I'd also like to encourage Congress not only to make sure that small business and Americans in general are protected against lawsuit abuse, but to look at the legal infrastructure of America, which hasn't gotten the kind of review that it deserves after 40 years of increasing litigation. The cost is far greater than the sum total of all the lawsuits. The cost is to the culture of America. If you visit any public institution of America, any school, any hospital, any workplace, any government office, the main sense is not, yes, we can, but no, you can't. And the reason for that is because people are fearful of being sued or fearful of violating rules they may not even know about. No teacher in America will put an arm around a crying child today. Why? Because they're scared of lawsuits. It's this, if you visit any playground in America, there's nothing athletic in it. There's nothing that would attract a child over the age of 4. No seesaws, no jungle gyms, no high slides, no merry-go-rounds. I remember the age of 4 or 5 climbing up this slide, heart beating. It was so high. It was 100 feet high, or 6 feet high. And it was, you know, and what the doctors and the child experts tell you is taking those risks and learning how to take responsibility for yourself is how children learn to be resourceful. But because of fear of lawsuits, all of that has been ripped out. Broward County, Florida, last year banned running at recess for its schools, many others as well, and we have a crisis of obesity. So we have a culture that's been transformed by the fear of lawsuits. And the solution is not, quote, tort reform, it's not to put artificial blocks on lawsuits, is to create the conditions for reliable justice. And the most important, and that includes standards from legislatures, but probably the most important innovation, I just had lunch with the Chief Judge of the Second Circuit. We happened to be on the train coming down together, which he and I have been working on this together. The most important innovation would be to give judges the authority to draw the boundaries of reasonableness when a claim will affect people not in the courtroom. If somebody brings a lawsuit because a child fell off the seesaw, not that it's broken or anything, say it's an unreasonable risk, someone, if the legislature hasn't spoken, has to draw a boundary about whether that's a reasonable risk. Otherwise, just allowing the claim to go forward, doesn't matter what the jury does, will mean all those seesaws will get ripped out all across the country because no one will take the risk. If judges don't get that authority back, it's a form of activism, but it's defensive activism. What you've done is given the unilateral power of the state to whoever brings the claim. Because bringing a lawsuit is just like indicting somebody, you're just indicting them for money. And if nobody in the courtroom sees it as their job to protect the interests of the common good, then whoever brings the claim in their own self-interest will have effectively set a lowest common denominator standard for the rest of society. In 2006, the House of Parliament passed a law explicitly telling the judges in the United Kingdom that they had to consider the interests of the broader society in letting claims go forward. And nothing would be better in this country to begin to restore trust in the system of justice than that particular reform. Are my 5 minutes up?
They are. We're going to come back and
Great.
have a chance to follow up with some questions. Thank you very much. Our next witness is Crystal Chodes. As I said in my opening statement, the cost of defending a lawsuit can be high enough to drive a small business out of business, even if it's done nothing wrong. Ms. Chodes was an employee at such a small business by the name of Basketball Town. Basketball Town was a facility that hosted children's holiday parties, birthday parties in particular. Despite striving to comply with the law, Basketball Town found itself the defendant in a federal lawsuit. Sadly, the costs associated with that lawsuit forced Basketball Town to close its doors. Ms. Chodes holds a Bachelor's of Arts in Communications from California State University in Sacramento. She lends her communications talents to such diverse causes as Sacramento Children's Home, Aspira Foster and Family Services, the American Lung Association, and other good works. Ms. Chodes brings the same commitment to serving her community to her same commitment to her advocacy for protecting small businesses like Basketball Town from meritless litigation. She lives in Rancho Cordova, California, with her 11-year-old son. Welcome, Ms. Chodes. We'd be glad to hear your opening statement.
Thank you for having me here today. I think first we're going to go ahead and roll the video about Basketball Town.
Could you pull that a little closer to you? And thank you very much. Yeah.
My name is Crystal Chodes. I'm the former marketing director for Basketball Town, and I was with them for just over 2 years. Basketball Town was a special events facility for basketball, volleyball, various sporting events where kids and families could come and spend time after school and on the weekends in a positive athletic environment. At Basketball Town, we offer birthday parties for kids, and we had one scheduled for a little boy, and he invited one of his friends, and that friend brought his uncle, who is in a wheelchair. They have a choice of scheduling the birthday parties upstairs in the upper deck lounge or downstairs in the lower game area, and there was no preference given. Once we found out through the family that one of the guests expected was in a wheelchair, we actually offered to move the party downstairs, and they declined. And as a result, months later, we were served with a lawsuit. Some people in the community said, well, why didn't you just put a lift in and make it go away? But it's not that easy. When you're being served with court paperwork, you have to respond. You have no choice but to respond. Well, it takes a lot out of you just reading the letters over, responding to the letters. There are times when I remember looking through court orders and thinking, that's inaccurate. That's not exactly what happened. And then taking the time to put a statement together so that you can explain. Conference calls where you're on the phone for a couple of hours and you're thinking every minute that you're on the phone, this is costing more money that could be going towards the facility. It's so frustrating. Finally, as a result of all the legal fees associated with the lawsuit, we had no choice but to close the facility. There was a family pizzeria here, and they had invested all of their money into this. They had their family involved in it, and now the facility's closed. They have 2 kids that they've got to put through college. Just a small business, a great family, and they have lost everything. They're starting over. When the facility was originally built, it was approved as if. For Basketball Town, ADA compliance was important to us, and we were in compliance with ADA regulations, but it didn't stop them from suing us. Finally, as a result of all the legal fees associated with the lawsuit, we had no choice but to close the facility. And if it can close an entire facility that's meant to benefit children and families, it can hurt anyone, and that has to stop. That breaks my heart to watch that. Thank you once again for inviting me to testify today at this important hearing. Again, my name is Crystal Chodes, and for me, the issue of lawsuit abuse hits close to home. I was the marketing director for Basketball Town, a special events facility located in Rancho Cordova, California. We offered a safe, friendly place for children and families to play basketball, volleyball, and other sports in a positive environment. We also hosted birthday parties for kids in 2 areas, one on the ground floor and the other on the mezzanine level. In May of 2006, we hosted a birthday party scheduled for a boy and his friends and family. This was a routine event for our facility as we hosted hundreds of birthday parties and events each year. The family had not indicated whether they wanted to host the party upstairs or downstairs, and we scheduled the party in the mezzanine level. On the day of the party, we learned his friend was bringing an uncle who uses a wheelchair. and we immediately offered to move the party downstairs, but they declined. Then a few months later, we were served with a lawsuit. The issue for us was not that Basketball Town was out of compliance with either the Federal Americans with Disabilities Act or even the more stringent California State Disabilities Law. In fact, we were fully compliant. We'd even worked with the building's owners when we moved into the facility to ensure that the building was fully compliant with the laws. During the lawsuit, the plaintiff's attorney hired an independent expert on ADA compliance to come to the facility, and the plaintiff's own expert found no violations with regard to the second floor, which was the central question of the lawsuit. For Basketball Town, we didn't violate the law, but we were sued anyway, and the cost of defending the lawsuit ultimately became more than we could bear. After about a year of fighting the lawsuit, we were forced to settle and close our doors forever. The plaintiff's lawyer didn't just sue Basketball Town, and they didn't just sue the owners of the facility. Inside our facility, we had leased space to a small pizzeria. The restaurant was started by a family that had invested virtually all of their life savings into this business, and they too were sued. When Basketball Town was forced to close, so was their pizzeria. And this family was just trying to get ahead and put their kids through college. Now they have to start over after losing their life savings. Not only did they lose everything, but they are still receiving legal bills for their defense, and they'll have to pay those off too. Basketball Town was built to serve families and kids who needed a safe place to hang out, and I'm proud to say that at the height of our business, we served about 100,000 families in our community each year. When we closed, there was no real alternative in Sacramento for many of these kids to go to after school and on the weekends. Many children I know were devastated, and it was their second home. And I still see people today, nearly 2 years after our closure, who remain devastated by our unfair and unjust ordeal. Basketball Town had about a dozen employees, and those jobs are gone. And today, as you know, we need to find ways to increase jobs in our community, not eliminate them. Since Basketball Town's closure, I have looked for ways to speak out against the devastating effect of abusive lawsuits on families, kids, and small businesses, the backbone of every community in our country. And in doing so, I have met other small businesses who have been hurt by abusive lawsuits. Senators, thank you for inviting me here today to speak on this important issue and to represent the tens of thousands of small businesses, their customers, their employees, their neighbors, and their communities who are struggling with this issue. And on behalf of them, I ask for your help to work against unwarranted and abusive lawsuits. If a lawsuit can close an entire facility that's meant to benefit children and families, it can hurt anyone, and it has to stop. Thank you again for having me here today.
Thank you very much. Our next witness is Dr. David Teuscher. Dr. Teuscher is has an active orthopedic surgical practice in Beaumont, Texas. And his subspecialty interests are in sports medicine and arthroscopic surgery. He serves as a team physician at Lamar University and with several area high school teams as well. He served both on with the Texas Medical Association and the American Association of Orthopedic Surgeons as chairman of their respective committees on professional liability and as the editor of the AAOS publication, Orthopedic Risk Manager. During the debate in Texas at the beginning of the decade that Senator Alexander alluded to, Dr. Teuscher played multiple and pivotal roles in the passage of medical liability reform, establishing caps on non-economic damages that have served as a model for the nation. Dr. Teuscher is the past president of the Jefferson County Medical Society and the Texas Orthopedic Association and continues to serve on the board of directors as such. He earned a Bachelor's of Science from the University of Illinois at Urbana-Champaign, an MD from the University of Texas Medical School at San Antonio, and completed his postgraduate training at Brooke Army Medical Center at Fort Sam Houston, Texas. A U.S. Army veteran of 13 years, Dr. Teuscher was decorated for service in Operations Desert Shield and Desert Storm. Welcome, Dr. Teuscher. We'll be happy to receive your testimony.
Thank you, Senator. It's an honor, privilege, and senators to be here. You know, it's interesting that the public policy debate here seems to be centered around three items: jobs, creating jobs, small businesses, and healthcare. And the President's very clearly talking about that. Well, in medicine, we try to go based upon evidence-based medicine. You have to prove that it works before we're going to give that pill to a patient or do that type of surgery. Well, there is one place where it is working. It's called Texas. And we made some very difficult decisions in the earlier part of this decade. Right now, the Texas economy is resilient. Doctors are literally flooding into the state. And small businesses, which doctors are increasing, not decreasing. Doctors are really a small business when you look at what they do and where they are. And unlike Basketball Town, you can't pick up Basketball Town and move it to a more friendly venue, but you sure can a doctor's practice. Senator Alexander, when Texas was in its early formative stages, folks from Tennessee had hang a sign up on their door that said GTT, gone to Texas. Well, there's a lot of those signs hanging on a lot of your doctor's doors. We're the beneficiary, and unfortunately, the patients who want access in Tennessee are paying the price. We know from our estimates, a doctor's practice and the economic activity that happens with that brings about $700,000 to the communities that have those. So in the rural and poorer parts of state of Texas, our lawsuit reforms with regard to medical liability have been a tremendous boon. Now, you're going to hear a lot of disinformation, misinformation, and it's from the usual suspects in Kaiser Sose. And I know that it's a little difficult to believe that they would say, one, that it wasn't a crisis, two, that it didn't work, three, that the rate of increase in doctors is equal to the rate of the general population growth, and it goes on and on. In your packet, I've given you a lot of material that basically rebuts that. There's a PowerPoint which shows you the statistics of how we were in a crisis. It specifically talks about before the reforms that there were 17 carriers that went down to 4. We had no carriers that would write policies for many, many of our physicians, and physicians had to pay, in many cases, 6 figures in order to cover themselves on an annualized basis. Quadrupled in non-economic damages during that same period of time. It was basically an explosion of litigation. And at that same time, 87% of those litigation cases never went anywhere. They were dropped or dismissed. But every one of them cost an average over $25,000 to defend. Well, who bears those costs? Well, ultimately, you can put a dollar number on the cost, but it's really not about that. It's about access to care. Because what happens when doctors feel like they have a high risk of being sued, or they've been sued over and over and over again, oftentimes and very commonly, not with any particular merit to that? Well, they do several things. One, they move to a more favorable venue. Two, they get off of emergency room call and limit their propensity to take those type of cases that are litigation prone. They restrict the type of practice that they have to less high-risk cases. So the people who very much need that care the most are probably not going to have access. You can't put a number on that. But here the numbers are compelling. And what you can find on the very last page, 2 pages here, you'll see a graph that shows the number of newly licensed physicians in Texas. Here's where we're at before reform. Here's where we're at now. And if you look at the page immediately before that, these are applications. The applications are the leading indicator. You have to apply before you can get a license. So we know that next year we're going to be up here and up here. This is a 60% to 80% increase over what we had before reforms. We were licensing a little more than 2,000 doctors a year. Last year was over 3,600. That's incredible. We've already gone from association before we passed reforms. Now we aren't even on the watch list. In fact, we are the model. So what we would say to the Senate, and certainly to this administration and to the Congress and the American people, is that we have an example of how to do it and how to do it right. And it's working. It's working for jobs. It's working for small business. It's working for health care. Now, a lot of people think, well, that really doesn't have anything to do with the federal government. Well, that's nonsense. We know, and I think Congressman Burgess is carrying a bill which would institute a Texas-sized cap at the federal level. Billions of dollars of savings through the Medicare system, because the more we pay in liability costs, the more we get paid by Medicare. I think that's something where doctors would actually agree to a pay cut if you could cut our liability costs, and this type of a plan really does that. So those type of reforms have to be meaningful, they have to be measurable, and they have to be sustainable. And we believe that ours are. And I'll stop there and be ready to answer any questions that you may have.
Thanks, Dr. Teuscher. Our next witness is Professor Christopher Drahozal, the John M. Rounds Professor at the University of Kansas School of Law. Professor Drahozal is a leading scholar of the law and economics of arbitration. He's an associate reporter for the Restatement Third of the U.S. Law on International Commercial Arbitration and has authored a casebook on commercial arbitration. Professor Drahozal is also the chair of the Consumer Arbitration Task Force of the Cyril Civil Justice Institute at Northwestern University School of Law. In that capacity, he contributed to a report this month on consumer arbitration before the American Arbitration Association. Prior to teaching, Professor Drahozal was in private law practice in Washington, D.C., and served as a law clerk for the Iran U.S. Claims Tribunal, Chief Justice Charles Clark of the United States Court of Appeals for the Fifth Circuit, and Byron White of the United States Supreme Court. Professor Drahozal, welcome, and we'd be happy to receive your opening statement.
Thank you, Senator and Senator Sessions. I'm very excited to be here today talking about arbitration, which I find it's nice being in a setting where there's interest in arbitration as opposed to some other settings. Arbitration is actually a perfect topic for this hearing because the growth in the use of arbitration is an illustration that something is wrong with the court system, that people are opting for private alternatives when the public alternative is ineffective. And the sorts of reasons that parties contract for arbitration are precisely the sorts of reasons that have been identified here today as potential problems with the court system, that it's too expensive, that the costs are too high, that there's a risk of frivolous or unpredictable lawsuits. And arbitration provides an alternative to litigation to resolve disputes that, again, parties have found increasingly attractive because of some of the uncertainties of the court system and the costs that go with it. As you noted, Senator Cornyn, in your opening remarks, that alternative has become increasingly controversial, that there are criticisms of arbitration, particularly in the consumer and employment context, as being unfair to consumers, unfair to employees. Conversely, supporters of arbitration cite, as you noted, that it can be less expensive than litigation and that it may actually enhance access of consumers or employees to a dispute resolution forum. In evaluating arbitration as a substitute for litigation, there's a notable lack, particularly in some settings, of empirical evidence, that you hear a lot of anecdotal stories about experiences in arbitration, but particularly in the consumer setting, there has been very little systematic empirical research. And with the Cyril Consumer Arbitration Task Force, we have tried to address at least some of those shortfalls in the report that, as you noted, we recently issued on consumer arbitration. The study focuses on the American Arbitration Association and how it handles consumer arbitration cases. We reviewed over 300 case files that the AAA administered basically from April through December 2007 and evaluated how the arbitration process worked on a variety of dimensions. Interestingly, the sample of cases that we looked at it certainly includes large businesses, but it includes a number of small businesses as well that have used arbitration as an alternative to the legal system for resolving disputes. We looked at a wide range, the cases involved a wide range of disputes and took place all over the country. Just to give you some idea of what we found, for example, was that the AAA has already adopted a system whereby consumers are charged for small claims quite low fees, $125 for a very small claim below $10,000, $375 for a claim below $75,000. And in fact, the fees that the consumers ultimately bore turned out often to be less than that, because when the case was resolved in an award, the arbitrator often protected consumers for some of those fees and assessed them to the losing party. The average time it took from start to finish to resolve disputes in AAA consumer arbitration was less than 7 months. Now, one thing that we intend to do in the future with this study is to have firm data on the court system, but certainly my intuition is 7 months from beginning to end is fairly expeditious dispute resolution, at least certainly compared to my experience and practice prior to starting to teach. Consumers prevailed in just over 50% of the cases that they brought, recovering a little less than $20,000. Conversely, businesses prevailed in roughly 83% of the cases they brought, recovering slightly more than $20,000. Our sense is the reason for the difference there is that businesses bring different types of claims than consumers do, that they tend to have liquidated claims for debts they are owed, and so businesses are more likely to prevail. It's easier to establish the claim and the amount. That consumers are in the cases that they are bringing, asserting claims for defective products or sort of poorly rendered services, harder to prove, harder to recover. The difference between businesses and consumer claimants, in our view, doesn't show any sort of unfairness of the arbitration process necessarily to consumers. And then finally, a big controversy in the consumer setting deals with clauses that at least assertedly are unfair to consumers based on different sorts of provisions that they may have that restrict recovery of damages and so forth. The AAA adheres to what's known as the Consumer Due Process Protocol, which are fairness standards requiring the arbitration process to be fair to all parties. And the study also looked at AAA's enforcement of that protocol and essentially found that in 98% of the cases, the arbitration agreement either complied with or that the AAA identified and properly enforced the protocol in the cases before it. Those are just highlights of the study. It's a very long study, as you may have noticed, and I'm not clearly going to want to try to talk about all of it, but I'm happy to discuss other findings or the arbitration process more generally if you all have questions. Thank you.
Thank you, Professor. Our final witness is Ted Frank, who's an expert and scholar in the areas of civil litigation and lawsuit abuse. He enjoyed a successful 11-year career as a lawyer in private practice before joining the American Enterprise Institute in 2006. At AEI, Mr. Frank's research focuses on class actions, mass torts, and civil justice reform. He's a frequent contributor to the popular weblog overlawyered.com, which documents abuse within the American civil justice system. He's a graduate of Brandeis University and of the University of Chicago School of Law. After law school, he clerked for Judge Frank Easterbrook of the Seventh Circuit, and he joins us today to discuss the economic costs of litigation. Welcome, Mr. Frank. We'd be glad to receive your opening statement.
Mr. Chairman, I'm going to need to run to the floor. I hope to be back shortly.
Thank you.
Thank you, Mr. Chairman and members of the conference, for your kind invitation to testify today about the magnitude of the effect on the economy of excessive litigation. Just to clarify, I'm a resident fellow at the American Enterprise Institute, but I am not testifying here on their behalf, and the views that I'm sharing today are my own. Our nation's tort system is substantially more expensive than that of other nations. Features unique to the United States: unbounded non-economic damages, the threat of punitive damages, contingent fees for a percentage of recovery, the lack of loser pays, broad discovery procedures, class action litigation, speculative and non-scientific expert testimony in some state courts. All of these raise costs tremendously. Yet, despite these increased costs from these unique features, there is no evidence that the United States tort system provides marginal benefits relative to the tort systems of other nations. If anything, it's quite likely that the arbitrary and random nature of the American tort system has distorting effects that make it perform worse than that of other nations, and Mr. Howard has written 3 books showing that. My written testimony explores existing economic studies on the direct and indirect marginal costs of the United States tort system. I conclude, first of all, that the direct costs of the United States economy from tort litigation are $252 billion a year, and that's about twice what twice relative to the size of the economy of what other industrialized nations spend. So in other words, we're spending an extra $128 billion a year over that of comparable industrialized nations. But it's important to recognize that the indirect costs, above and beyond the direct costs caused by excessive litigation, far outweigh these direct costs of paying attorneys, paying damages. Businesses incur non-legal expenses to comply with the tort system, from document management systems to executive time lost in depositions and pretrial preparation to activities forgone because of legal risk. Businesses and individuals change their behavior in inefficient ways because of the distorting effects of the tort system. For example, because of the risk of employment litigation, every employee a business hires is a potential lawsuit. Now, employers are rational economic actors, and confronted with this potential cost, they reduce wages or substitute away from labor into other means of production to reflect these additional costs. And studies have shown, and I estimate, that there's over $400 billion a year of deadweight loss and millions of lost jobs from the effect of the tort litigation on wages. Fear of liability causes doctors to engage in defensive medicine, manufacturers to refrain from innovation, and pharmaceutical companies to cut back on research and development. As I discuss in more detail in my written testimony, I estimate that these indirect costs add up to between $70 billion and $375 billion a year of deadweight lost, as well as thousands of lost lives every year. All in all, the total loss to the economy from excessive tort litigation can be estimated, and admittedly a rough estimate, at between over $600 billion and over $900 billion a year, or 4 to 6.5% of GNP. That's a tort tax between $8,000 and $12,000 a year for an average family of 4. In short, we could achieve both better and more permanent results than the recent stimulus package without spending a dime of taxpayer money simply by passing comprehensive tort reform. Now, I want to emphasize that these are very large numbers, but they're also very likely an underestimate for several reasons. First, I've used conservative estimates for all of these numbers. In each of the categories I've discussed, other economists have looked at the same data, and they've come away with higher numbers. Second, none of these numbers account for the likely effect of recent congressional expansions of tort liability in the last few months. The Americans with Disabilities Act, Amendments Act of 2008, the Lilly Ledbetter Act, the Cpsia, all of these raise costs to employers and businesses, will put tens of thousands of businesses out of business, and will cost jobs. Third, I have not tried to estimate a number of identifiable secondary and tertiary effects of excessive tort litigation on the allegation of economic resources. I don't measure the damaging effects on the culture that Mr. Howard describes. The demand for lawyers is such that even in the middle of a recession, a 25-year-old law school graduate working for Mr. Howard's firm will make more than a U.S. senator. As a result, we have a distortion in the economy. Many of the best and brightest college graduates will choose to become attorneys rather than engineers or scientists or other jobs where people produce things rather than working to transfer wealth or prevent the transfer of wealth. I have not measured the economic effects of this brain drain, nor have I measured the economic effects of securities litigation on raising the cost of capital and increasing the barriers to entry to startup companies. $600 billion a year is almost certainly an underestimate of the true costs of the American tort system. I welcome your questions.
The atmosphere in our country sort of changes the culture in subtle and not so subtle ways. But I want to talk with you just a second about our global competition when it comes to job creation and be able to retain people in jobs during a tough economic environment. Do the costs of liability insurance, do the costs of, let's say, paying for employees who are unproductive because they have to leave the job in order to testify in depositions or in court or in other ways, how does this impact the United States of America in terms of our ability to compete in a global economic environment that our litigation system is so costly and takes so much time from employees and employers alike?
Well, it's clearly a very large drag on the economy and on our competitiveness, and there have been a number of studies showing this in the financials industry. In the financial industry, there's been a bipartisan study by Mayor Bloomberg and Senator Schumer lamenting that litigation costs are hurting the competitiveness of what was once the foremost financial industry in the world. The National Association of Manufacturers has released a study showing a drag of several percent on manufacturing industry from just direct tort costs, not even including the indirect tort costs that Mr. Howard and I have discussed, and that is that certainly hurts our manufacturing capability, and so on and so forth. The CEO of Chrysler has said that litigation costs raise the cost of every car built in America by $1,000, and that's billions of dollars a year to consumers, and no telling how many lost sales and lost production we've had because of that.
I've heard you use the term tort tax, which I've actually heard and read before, but is it your contention that these increased costs on small and large businesses alike are absorbed by those businesses, or are they in fact passed down to the ultimate consumer?
Well, it's in a lot of ways a deadweight loss. We don't see the products that aren't created, the people who don't become doctors, the drugs that aren't built. So it's a tort tax in that it's literally wealth destruction. Certainly the direct cost, the $128 billion, a lot of that gets passed on to consumers, and we see that in the increased price of cars. But what we also lose is the wealth destruction, the jobs that aren't created, the businesses that aren't started. And those indirect costs cost individuals, families, thousands of dollars a year.
Mr. Howard, you've, as I noted in the introduction, you've written extensively and spoken extensively in this area, and as well as established common good for forging bipartisan coalitions to deal with these issues. But I mentioned that your latest book has perhaps the most provocative title of all, Life Without Lawyers. And having been a lawyer myself for 30 years and have a daughter who is about to graduate from law school, could you explain what you mean by that and how that pertains to the conversation we're having here today?
Well, I think it's, the title of the book is intended to suggest that people in living their lives should be able to focus on their goals, not worry about the little lawyer on their shoulder whispering in their ear that they might get in trouble. So it's not actually about getting rid of all the lawyers, although the proportion of lawyers in the workplace has doubled in the last 30 years, as you know, for some of the reasons that the other witnesses and Mr. Frank have testified. People can't succeed if they're self-conscious. It's a cognitive problem. I talk about it in the book. If you're worried that you're going to get in trouble, the mindset of the doctor is, well, maybe it's unlikely that that headache could be a tumor, but you never know, and the insurance company will pay for it, so I guess I'll order an MRI. Pretty soon you have $2,000 wasted, and that adds up over time to an extra $100 billion in defensive medicine. So if people don't trust the system of justice, they won't behave sensibly. The teacher won't maintain control of it. So you need them to live their lives focusing on their goals, not worried about the distrust of justice, not worrying about the lawyer. So that's really what the book is about. And on global competitiveness, without any question, the most important thing that could happen for this economy is to overhaul the legal infrastructure to make it reliable. Foreign investors say they won't come because they're scared of the 1 in 100 chance of a rogue verdict that ruins their business. Why should they take that risk in America if they could go invest in Singapore or someplace where they don't have that risk? Employment frictions drive up costs there. Healthcare costs can't possibly be fixed without a reliable system of justice for the reasons I just stated, because you can't align the incentives of the doctors. So it ripples out through the society. It could hardly be more important.
Dr. Teuscher, you indicated, of course, you and I know each other well and familiar with the Texas experience, and I try not to emphasize that too much up here in Washington because people don't appreciate it in Washington as much as I do or you do when we talk about why Texas is the model in this area, but I think it's true. And both Mr. Frank and Mr. Howard have talked a little bit about this phenomenon of voting with your feet. If you're an employer, deciding where to put your business, or if the costs of overhead, insurance costs, of litigation costs are too high. You alluded to the fact that in Texas, we found that a lot more physicians are willing to come and practice their profession in Texas, and there's a lot more access to health care in Texas because there are more doctors providing that health care because of the certainty, or at least greater certainty, caused by the tort reform efforts in our state. But could you talk just a little bit about the impact on high-risk specialties in particular? Because I think this is an area, even where there may be a doctor in town, there may not be a neurosurgeon, or we've talked about an OB-GYN doctor and the like, what the impact has been with regard to those specialties?
The high-risk specialties were probably those that were hit the hardest. Our pediatric subspecialties, neurosurgery, orthopedic surgery, obstetrics, ER medicine, some of the critical care areas. And those are the areas that were suffering some of the greatest lack of access for our patients. And again, you know, I think both of these last two comments are right on target. It's the subtle stuff that you can't measure that are killing us. And defensive medicine is bad medicine. It's ordering tests and procedures to cover my rear end. It's not to make your health any better. And it's very, very expensive. It's very insidious in that. And I know in talking to colleagues that many of them feel emboldened at this point in time that they'll only look at the facts in the case and simply say, you really don't need that test. we're going to watch you for another 60 days if the symptoms change. If your headache doesn't go away, you don't need the test. And I think that this gotcha mentality that goes on with the courts is really got to have some limitation. I don't know that I want everyone to adopt what we did in Texas. I think the doctors would quit coming if they had a stable environment in the other 49 states. But I do know this, we don't want any federal reform to usurp what we've already done there. In your materials, you also have a study by Dr. Ray Perryman. I know you're very familiar with Dr. Perryman. And it talks not just about the medical liability aspects, but also the general business climate. Right now, Texas is home to more Fortune 500 companies than any other state in the country. And I think if you would have told New York that 30 years ago, they probably would have not believed us. But capital is going to move to where it gets treated appropriately, where it has lower risks and higher potential rate of return. So as we look at that, already in 5 short years, the pediatric subspecialists in Texas has doubled. The number of orthopedic surgeons across the state in 5 years, only 5 years, up 12%. Neurosurgeons up 12%. And in my community where we didn't have full-time coverage, in our trauma center, we now have 24/7 coverage for all of those critical specialties we talked about. And that's only 5 years, Senator. It's not very long. And I think as you saw by these statistics, that upswing continues to move in that positive direction. We haven't added any more medical schools. We haven't added medical students. We haven't added residencies. These are doctors, some of them the best and the brightest across this country, that are coming to Texas. And our ability to recruit is increasing. Now, the other side will say, well, yeah, you get the bottom of the barrel. Not true. Before reform, 98% of applicants got a license. Since reform, it's at 85%. So we're able to be very selective in the ones that we're allowing in. And that's the attraction that we have. And I can tell you from a personal standpoint, I've had partners that retired or left ER call or limited their practice. That's very subtle. They still have a license, they're still in practice, but there's not access for the patients. And it's those high-risk cases, high-risk OB. When do you let your kid ride his bicycle? Do you have an orthopedic surgeon or neurosurgeon to save his life on call in your emergency room? These are the things the public doesn't even understand that's happening to them. People have to understand this question. Do you want access to emergency care or do you want access to the courts? And that's the real question.
Well, and Dr. Teuscher, just lest anybody get the wrong impression, the primary reforms in Texas have been putting caps on non-economic damages and punitive damages. Someone who still suffers as a result of negligence on the part of a health care provider still has just as good access to the courthouse as they did before this legislation passed, do they not?
Real damages are never capped in Texas. We've had a wrongful death cap for 30 years. The non-economic cap only affects those things that are not measurable or not quantifiable. But when it comes to your medical bills before or after a settlement or a judgment, if it comes to your disability payments or your care plan, if you're disabled and you need somebody to take care of you, those are uncapped. The sky is the limit. But those are objective measured that generally both sides, the plaintiff and the defense side, can agree within 10%. What warped out all of the judgments that were happening before reform was a quadrupling in a 10-year period of the non-economic side of that. So that was what was exploding. And when you go to court, you're supposed to be getting damages that can be compensated that are real damages. And those compensations, that's the reason you're in court. It's not there to discipline doctors. That's what the medical board does. And in fact, it's a very inefficient way to even think that you're disciplining anybody over the bad behavior. If you look at only 1 in 7 actually trials ever comes out with a plaintiff judgment. And that's very, very expensive in the system.
Mr. Howard, you and I have talked in the past about the impact, let's say, on Medicare and other entitlement spending, which is growing into huge crisis proportion, some $67 trillion in unfunded liabilities that are not even touched upon, really, in the budget proposal Congress will be taking up. And innovations like medical specialty courts and the like. Could you explain what impact you think that innovation and others would have on the unfunded obligation of the American people when it comes to Medicare?
Thank you, Senator. I don't think it's possible to contain healthcare costs unless you create a system of justice that the providers trust. And by the way, the current system, it should be noted, is terrible for people who are injured by mistakes. A study 2 years ago by Harvard of thousands of cases found that it took an average of 5 years to get to settlement, 5 years for payment, and 54% of the cost went to lawyers' fees and insurance companies. So you have most of the malpractice dollar not going to the patients, an injured patient waiting 5 years, or a doctor unfairly charged, often waiting 5 years to get justice. Meanwhile, he can't sleep at night. So the current system doesn't work for either side. A broad coalition has come together behind the idea of doing pilot projects of health courts, including the largest consumer groups in the country, AARP, all of the patient safety groups, these are not tort reformers, and as well as all of the providers. And the way this would work is it would be an administrative process, not unlike sort of applying workers' comp or a fast-track arbitration system, but it would be with written opinions by expert judges who would be advised by neutral experts, and all the information would be captured that comes in even in settled cases. Doctors and hospitals would have the obligation to disclose all the information about the case, and it would be expected that more people would be compensated in an average of a few months with dramatically lower administrative costs. But the main virtue is not just that it's a better system of justice, is that doctors could trust the system to affirmatively protect them in the situation where the sick person got sicker and it wasn't their fault. And that foundational level of trust is not the only thing needed to save Medicare costs. We also need to reform the fee-for-service model and realign incentives, which is unavoidably complicated, I think. I know you've been working on that. But it is one of the foundational steps needed. And again, the coalition's ready. The only people who oppose it are the trial lawyers.
Professor Drahozal, when I was early years of my legal practice, and I became concerned that there were a lot of people who had legitimate grievances, but unless they could find a contingency fee lawyer to take a contingency fee interest in their case, then they wouldn't be able to find a lawyer to take their case to court, for example. And so in the early stages of both my legal practice and then my judicial career, Chief Justice Warren Burger made a famous speech where he said that the time and expense of ordinary litigation is just as much a bar to access to justice as any other impediment or any other obstacle you might put in the way of an ordinary citizen. So the alternative dispute resolution movement sort of arose out of that in order to provide a less expensive, more expeditious resolution to disputes. And of course, as you know, contractual arbitration provisions have long been included in various agreements. I would just like to ask you, are you beginning to see sort of a trend here where Congress is beginning to step in and say that certain types of arbitration agreements are unenforceable? And are you concerned that by Congress intervening into these contractual relationships that both the expense and delays of ordinary litigation will do nothing but increase, and perhaps there are other unanticipated, unknowable ways in which this will have an effect? Would you share your thoughts?
Well, my guess is you probably have a better sense of Congress, what Congress is doing than I do, but certainly there have been a number of statutes passed in recent years that have made unenforceable pre-dispute clauses, and Arbitration Fairness Act, which is currently pending was recently reintroduced in the House, would do that as well. The issue of access to justice is an important one. It's something our study, that the Searle study, touched on only tangentially because sort of by definition everything we saw was a case that did make it to arbitration. But certainly half of the cases that we looked at, the individual, the consumer, was able to proceed in the arbitration process without a lawyer, that they did not need a lawyer. And in fact, it was striking to me as someone who was a practicing lawyer before going into teaching, how effective consumers could be acting without lawyers. And frankly, in some cases, and this may be what Mr. Howard, an example of something from Mr. Howard's book, lawyers were actually counterproductive, that the consumer was the individual was very effective in stating their case in a very sort of concise, straightforward manner. You would get lawyers involved, and instead of having a one-paragraph description of a claim, you would have a 30-page complaint that was written in legalese, and it just made matters worse. So, I mean, you see some of that in arbitration, but presumably less than one would think that you would see in the court system. The one study, again, our study is limited in what it can do about access issues, but the one study that has addressed that issue, and certainly some of the other commentators that have done research into the issue, have suggested that arbitration provides access to persons who may not be able to proceed in the court system. That because of lower legal fees and the informality of the arbitration process, people can bring claims in arbitration that they might not successfully be able to bring, or be able to bring at all, in the court system. And certainly to the extent that statutes that statutes restrict the availability of arbitration, they may reduce the access that individuals would have to that alternative.
So contrary to what you hear in some quarters, actually arbitration can enhance people's access to justice rather than jeopardize that.
Yeah, particularly for smaller claims that would be uneconomical to bring in the court system. That's what the available evidence suggests. Yes.
Could you give us just sort of an example of the most common sort of arbitration provisions? What kind of instruments, what kind of claims are, in your experience, most likely to be subject to arbitration provisions?
It varies tremendously. I mean, and there's sort of some industries have very high uses of arbitration clauses, such as the credit card industry and cell phone industry. But again, there's a number of small businesses. Car dealers often use arbitration clauses in their contracts with buyers. In our sample, I guess there were real estate agents. There were perhaps one of the more interesting ones, a business that provided hair extensions and permanent lip lining. I mean, it's sort of all arrays, frankly, of businesses do use arbitration. There's just differences in frequencies. And
this could also include, and does frequently include, very sophisticated business entities, correct? There they agree to certain provision as an alternative to the expense and time that would be eaten up during ordinary litigation.
Absolutely. And again, our study looked solely at consumer contracts. But absolutely that sophisticated businesses in dealing with each other, most dramatically in the international setting where for many sorts of contracts, everybody or virtually everybody uses arbitration clauses. I mean, there's exceptions always, but that arbitration or that businesses as well as, or often in their dealings with other businesses, certainly will use arbitration clauses. And in the international setting, exactly the sorts of concerns that we've heard about the American legal system often when parties from other countries are dealing with American businesses, that would be why they would not want to litigate, and they would want an arbitration clause.
Ms. Chodes, thank you for being here as well. I think it's particularly important that someone like you come and testify at a hearing like this, because it's easy to talk in policy terms and in numbers, but it's always more poignant and I think much more informative to have somebody come and relate their personal story. Let me just ask you a little bit about Basketball Town. Did you say that it employed 12 people?
Yes.
And so when Basketball Town went away, those 12 people lost their jobs, I suppose.
Yes, they did.
And then there was, in addition, this other business, this pizza business. How many people did it employ?
It was a family-owned operation, so the couple that owned it and their 2 kids often came in on weekends and worked inside the pizzeria.
And so presumably, they were either able to find another place to run their business or else they were put out of business.
They were put out of business. The wife was looking for a job, and again, the kids are off to college right now, so they're just struggling to meet that need, and then again, pay the legal fees on top of it that seem to be piling up.
So even though your basketball town was complying with all the applicable regulations and laws, just the very cost of defending a lawsuit was enough to give the economic death penalty, I guess, to those people in that particular small business.
Right. Yeah, that is correct.
And can you talk to me a little bit about what small businesses do ordinarily to protect themselves against those? For example, the cost of insurance. Does that have an impact on your bottom line and the ability to hire and retain more employees? Let's say if you decide to spend whatever it takes to pay for liability insurance to protect you from those legal fees and any judgments. Is that something that you would have to take into account in determining how many people you could hire?
Absolutely, absolutely. With a business like Basketball Town, the overhead is so high, and the revenue that you generate is so low. It's really a labor of love working and maintaining a facility like that. And the cost of insurance, yes, it definitely affects the bottom line.
Well, I want to thank all of you for being here today, and I want to, we've had Senator Sessions, Senator Alexander here. We've also have C-SPAN recording these proceedings, so there are going to be other people that will see what we've talked about here, other than those of us who are physically present. I would just ask, is there any other topic, perhaps closing comment any of the witnesses might have on something that you think is important to the subject we're talking about here, but we haven't had a chance to either ask you a question on it or you haven't had a chance to offer your comments on it? Dr. Teuscher?
Yeah, I wanted to follow up with what Mr. Howard was talking about. Pre-reform, post-reform, the largest liability carrier in Texas is Texas Medical Liability Trust, which is basically a nonprofit trust that doctors put together to pool their risk. What they have found, and it's proprietary information, so I really can't tell you exactly what the numbers are, but what they have found is post-reform, that when they are making settlements, the settlements are at least half the time that it used to take to make a settlement. And because of that, it's actually at a higher amount. And because of that, those two factors, the injured parties, the truly injured parties, are not only seeing more dollars, they're seeing more dollars sooner, and they're seeing their lawyer having to spend less in the case, so more flows to that. And if that's not good public policy, isn't that what we're supposed to do? A true victim receiving more money sooner so that they can take care of their own medical bills, their own care, and not necessarily be a ward of the state. So I think that we're already seeing that in that regard. Now, in our reforms, it wasn't just the non-economic cap, although we think that was the cornerstone. We also had provisions for periodic payments. So when the amount went over $100,000 and it was supposed to pay for their medical care and future wages, that it would be paid out over a period of time. Well, we think that was good public policy because the person wouldn't get a large amount of money, spend it all that first year like they won the lottery, and that those monies would be then available in future years. Another part of that was a provision that raised the burden of proof to a gross negligence standard on emergency medical care, where oftentimes you can't take a complete history, you're not familiar with the patient, you're presented with an emergency and it's move, move, move. Well, we think that that should have been a higher burden of proof. That's a very important point as well. And then the other area is a affidavit of merit. It had to have an expert to file a report saying that there was negligence. And once you file the lawsuit, you have 150 days to produce that expert report. Now, that expert report, maybe you don't believe that expert or not, but if you can't find an expert to certify negligence, then the court is in a position to dismiss that. The other part that we really hadn't talked about is a part that they continue to put into every single bill that has something to do with health care, and that's physician-owned specialty hospitals. And as you know, in Texas, we have over 50 of those, employing over 44,000 people. and we have another 50 on the drawing board or under development. So if we're talking about jobs, we're talking about innovation, we're talking about healthcare, and everybody's talking about that up here, then I think we need to think that what the Mayo brothers did, what Scott and White did, was invest in their own facilities. And what better way to have that innovation than have one of the bosses in the operating room with everyone else? And so we think that's a good way for us to go from an economic standpoint.
Mr. Frank?
Yes, we spoke about how the Arbitration Fairness Act would reduce access to justice, but I also want to emphasize that it would reduce access to credit. These credit card arbitration clauses reflect free market competition to
Pull that a little closer to you.
Absolutely. These credit card arbitration clauses reflect free market competition to best lower prices to consumers, lower the cost of credit to consumers. And they were adopted in an effort to have a competitive advantage in lowering prices to consumers, and consumers get that advantage. And we have economists such as Paul Krugman talking about the risk of a liquidity crisis. It seems very strange that Congress would be passing a law that would act to raise the cost of credit to consumers and shrink the availability of credit even further.
Thank you for pointing that out. I think that's an important point to make. Well, thank you all for being here today. This has been very enlightening, and I think it will be an enormous benefit to my colleagues and myself as we encounter what I believe to just be the first of a number of attempts to either deal with health care without dealing with health care liability, to deal with arbitration agreements, not recognizing the importance that they have in terms of access to justice. And I think it's important to our ongoing conversation about how we're going to compete in a global society without having additional costs borne by American businesses or people we want to attract to create jobs here, by having not only a fair and just civil justice system, but also one that's fair to people who are sued as well. So thank you very much. The hearing is adjourned.